Hi, everyone. Welcome back to the Mission Mediation podcast. I'm Jonathan. For those of you who are not acquainted with my work, I'm a mediator based in New Delhi now. I'm also the founder and partner at the Pact. I'm joined by some fantastic guests on today's fifth episode of the Mission Mediation podcast. If this is the first time you're joining us, there are four other episodes archived on our YouTube channel. So please go and check that out and also subscribe to the next episodes so that you don't have to always be listening to us in terms of promotional material. Every time there's a new episode, YouTube and LinkedIn will tell you that there is a new Mission Mediation episode on your timeline. Once again, wherever you're joining us from, good morning, good afternoon, good evening. Thank you so much for joining us live. If you're joining us on YouTube, please say hello. If you're joining us on LinkedIn, please say hello in the comments box and tell us what's excited you over the last 1 week and what's happening in your world of mediation. I'm joined, of course, with my co-host today, Nishant Laroya, who is a mediator himself, a partner at PACT, and now an award-winning restaurateur, as I've just learned this evening. We won't have much time to get into that, Nishant, but because we got some fantastic guests to talk about building private mediation, building trust in private mediation. We got so much to dive deep into, but we just got 60 minutes for this. The PACT has spent the last 10 years working with lawyers, working with mediators, working with users to bring into the focus what private mediation means, how it's different from court-annexed mediation or court-referred mediation, the value of doing this in a setting where you can enjoy the process. We talk about different satisfactions in mediation. We talk about outcome satisfaction and psychological satisfaction and process satisfaction. And I can argue today to say that sometimes process satisfaction might not be best achieved in a court-annexed mediation center. But for those of you who feel differently, use that LinkedIn comments box. Tell me why you feel differently. We're not going to be mincing any words on the Mission Mediation podcast. Today, we're talking about building trust in private mediation. I'm going to quickly introduce you to two of our guests. I want to start off with Jonathan Lloyd-Jones, who's joining us today. Jonathan is a commercial mediator with the Independent Mediators Limited. Prior to diving deep full-time into mediation, Jonathan was a former solicitor and a partner at Blake Lapton. He's now the fellow and president of the International Academy of Mediators. And please do follow him on LinkedIn for some more details. And I heard that anytime that Jonathan misses some really good Indian food, he takes that very long flight from London all the way to India. Jonathan, thank you so much for joining us virtually today. Awesome. I want to quickly introduce you to Jawad. For those of you who don't know him yet, AJ Jawad is a senior mediator, a mediation trainer with the Supreme Court's Mediation and Resolution Project Committee, or most of us know it as MCPC. He's a visiting faculty at various national institutes and universities. And importantly, today, we want to introduce him as the registrar of International Arbitration and Mediation Center, Hyderabad, just promoting, once again, private mediation services. Jawad, thank you so much for joining us from Hyderabad.
Thank you, Jonathan, for calling me.
Awesome. Great. So we want to dive straight into these conversations. We like doing case studies on the Mission Mediation podcast. We like talking about real life mediations that have happened. There are a lot of forums out there talking about mediation. We talk about what's not working, what needs to change, aspirational stuff. But the Mission Mediation podcast is focused on telling you that mediation is happening, it's working. There are some great mediators out there. There's some great mediation institutes out there. And we're going to focus on precisely that today. Now, the word private mediation, just very quickly, the word private mediation is used quite often in different contexts. Some of us use it very loosely when we say private mediation. Some people call it institutional mediation. Some people call it commercial mediation. Some people call it pre-litigation mediation, independent mediation. So there's a lot going out there. But for the sake of the next 60 minutes and the Mission Mediation podcast, when we talk about private mediation, we basically mean mediation that does not take place in the confines of a court-annexed mediation building or in fact, even a courtroom, right? So private mediation basically administered by an institution or by a solo practitioner outside the confines of the court. Now, this could be pre-litigation, or it could be even after litigation begins. So private mediation is also considered private mediation once the litigation begins. It's not just pre-litigation mediation. It could be referred by the lawyers, it could be referred by the judges, it could be referred by the arbitrators, or it could be just the parties who come directly to the institute and say, we want to try mediation. So on that note, Nishant, over to you. Let's dive deep into private mediation.
Thank you so much, Jonathan. I mean, there's just so much that we can talk about as far as private mediation is concerned. But I think let's begin with asking, Jonathan and Jawad, when people move into private mediation, or even think about, there's this sense of mistrust. We always feel that the other party is out there to get us, correct, or we want to get a better deal, or what is behind the other party's offer. So why have they even chosen to be a part of the mediation? So I want to understand that trust plays an important factor in the success of mediation. What needs to be done to enhance that trust in a private mediation, um, so that we have a smoother process?
Okay, shall I go first?
Jonathan, go for it.
Thank you, and thank you for having me on your podcast, Jonathan. Welcome from Oxford, England. What to me is very interesting about this conversation is that it's exactly the conversation we were having in the UK about 30 years ago when I started mediating in the early 1990s. And looking back, I think there were two factors that one needed to address so as to build trust in private mediation. One is quite simply ignorance of the process. When mediators talk to other mediators, but they don't talk to the people who need to hear. And what I found really interesting in that time was people had very little understanding of what a mediation actually was. It wasn't that they were against it; they just didn't know anything about it. And so, the first thing I think one needs to do is to address that and publicize more the fact that it's there, it's respected, it's part of the dispute resolution process. And I think one needs to address the fact that it's not simply the end users, the clients, the commercial organizations that have the disputes that are ignorant. It's the lawyers as well who either don't know about the process or don't understand it. So I think there's a lot of education to be done in the early days as in terms of building trust. It's getting people to understand what mediation actually is and what it isn't, that it isn't arbitration. And so many people use the two words interchangeably. And of course, arbitration is entirely different, where a determination is made by an individual or a panel of individuals. Mediation, the mediator has no power to make a determination. The mediator's only power is to encourage and to persuade. And moving on from that, you then have to think, well, how do you develop that education? How do you build that understanding? And I don't think there's any one way. I think there's just lots of ways. It would be really nice to see greater reference to mediation in the media, on television, in the papers, in a meaningful way. It's very rarely, you very rarely come across mediation, apart sometimes family mediation. It's exposure to the fact it's a standard way of dealing with disputes. And I think finally, just on this, because I'm conscious we've got a lot to cover, it really made a difference once the judges started encouraging disputants to go to mediation rather than go to trial. That, certainly in the UK, was a major turning point when the judiciary started to understand what it was. That's probably enough from me at the moment. Shall I hand over to Joad to add to that?
I think, Jonathan, you made quite two impressive points where we're talking about publicizing mediation to increase the trust in private mediation, educating and getting people to understand what it is and what it isn't. Yes. Jawad, we know for a fact that we have this mentality when we are mediating inside court, like in a court annex center. People still feel, okay, you know what, this is still a part of the court, so there's that level of trust. But the moment it's outside, there's so many people who come and tell us that, oh, what if this mediator or this private mediator is passes a judgment on their behalf? These are things that we actually hear from clients. So how do we enhance trust in private mediation?
See, there are two things, Nishant. One is the strategic trust which parties should have in the process when they start with. And the second is the emotional trust that they gradually develop as the mediation proceeds, depending on how the mediator is dealing with them. But before talking about that, I think that is more to do with the process of mediation. But I think the question which you're asking me now is, how do you develop the public trust in a process called mediation? And how do you create that awareness that, okay, here is a process that you can take recourse to?
More so in private mediation, because when it's a court mediation, people feel that, okay, court is there.
Yeah. No, that is where. See, the thing is now, recently I was in Kochi in a university, and I was giving a talk on how important mediation is. The skills of mediation are for lawyers who don't intend to be mediators. But, so one of the points that I made over there was that I said that mediation is an essential tool in the toolkit of a lawyer. You're not a lawyer if you don't know mediation. Because all along, thanks to the Anglo-Saxon jurisprudence that we follow, and Jonathan said that 30 years back they were having this discussion, and it's really tragic that we are having this discussion 30 years later. We should have had this discussion much before. But the problem is we are more loyal than the king. Okay, so we have embraced the Anglo-Saxon jurisprudence of adversarial litigation to such an extent that has been the only tool in our toolkit. That's the only way we know how to resolve a dispute. Okay. Unfortunately, as the Zen saying goes, when the only tool in your toolkit is a hammer, every problem looks like a nail. So one of the essential things that especially lawyers need to understand is they need to know what mediation is and how the process works. And it should be the first port of call when a client comes to them for advice. They have to advise the client, go for mediation first. Because, this is what is happening today is something like what used to happen. Perhaps, Jonathan will tell us a little more about in the medieval days when somebody felt that their honor has been, if they felt affronted by somebody's action, they'll invite them to a duel, and you draw your swords and go into an open space and you fight a duel, and whoever wins his honor stands vindicated. And we are doing exactly today, and we are not even doing it directly. We are engaging the gladiators. We are engaging the lawyers who are nothing but glorified gladiators who go and fight in the arena called the courts. So what we need to do is, I think, this awareness has to come among the lawyers first. And fortunately, because as I said, we are so stuck with the system of jurisprudence that we follow, that unless there is a law on the subject, which is again, very paradoxical, because the process of mediation is designed to move people away from law and to appeal more to their common sense and, more rational thinking, dealing with their biases and prejudices and trying to solve a problem without invoking the law. But we need a law to get them to do that. So the passing of the Mediation Act in 2023 has been a game changer. Unfortunately, it has not been notified so far. But I feel that, as soon as the act was passed, surprisingly, I started getting a lot of referrals from lawyers, and I'm sure all the mediators have had the same experience. So lawyers suddenly realized that, okay, there is something called mediation and we should try it. And we are having a huge demand for people wanting to get trained in mediation. So it's happening. It's a slow process, but hopefully it should happen soon.
So I think, if I understood correctly, you're saying that the lawyers need to show faith and trust in the process, which is then passed on to their clients. I think it is a very, very valid point, because ultimately when there is a dispute, the first point of contact for a party is, happens to be their lawyer, right? Now,
Yes.
when we are sitting court annexed in mediations, there is always a limited time, and at times the cases are kind of marked to mediators, and they have to start from there. Whereas I think in pre-mediation you do get the opportunity of in a way you have more time, and there is work pre-mediation that can be done as well. So I'd like to know from you both, what kind of pre-mediation preparation do you engage with the client, say in high stake commercial mediation? This is completely before they have even had the first session. Jonathan?
Yeah, thank you. So the normal format that I follow in the UK and that has been adopted tends to be a full day of mediation. And so prior to that, the parties normally have instructed lawyers, and therefore there's quite a role on the lawyers to refine and understand what the dispute is all about, because that's what the client needs to have in the back of their minds when they come into the mediation. They need to have some understanding of what the dispute is about, what are the likely and possible outcomes, and an idea of what they're looking for from the mediation and from the mediator. And so and that's really important, because the mediator isn't there to give advice. And that can be a challenge where you have a party hasn't been to lawyers. But most of my cases are referred to me by the lawyers. And so what I ask them to send me are the key documents, so I can get some understanding of the dispute beforehand. I ask them to send me, if it's a dispute over a contract, I want to see the contract. If there's a dispute over correspondence that sets out the position, I like to see that. If it's actually already into court, but they're coming not as court annex mediation, but privately, then I like to understand how the case has been put before the judge, what the pleadings say. And maybe it's just the lawyers have exchanged correspondence. And again, that's helpful. I definitely don't want to see all the lawyers' correspondence. And then once and the other thing that I ask them to do is to set out in a fairly short document, no more than, if possible, 4 or 5 sides of A4, what they think the key issues are and why they think their case is stronger than the other side. So when I've got all that and I've read all that, then I will tend to telephone. It's normally the lawyers I telephone. Sometimes we do a Zoom call with the parties as well. And the purpose of that call is to introduce myself so that they know who I am. I can talk to them a bit about the process and answer any questions that they've got as to how mediation works. I don't very often talk in detail about the case itself at that stage, because I want to start to build a bit of trust and empathy between.
But would you end up making a call to the clients as well, or is it only to the lawyers at this stage?
Well, it tends to be mainly to the lawyers, but these days the advantage of Zoom or Teams is that they can bring their clients on for that initial conversation as well. And that's really helpful. And if I think there's a particular document or a particular issue that's going to be important, it might be damages. How are they going to quantify the damages? And I might say, well, what's the evidence you're going to bring? How are we going to deal with that? Or it might be another issue, and I will say, well, look, I think this is what is one of the issues. Can you give some thought to it beforehand? More rarely, but occasionally, I will visit if they think it's going to be helpful for me as mediator to see the site. I will actually go and visit the area, the site that the dispute is about. But that's quite rare, because I'm not sure it's going to help enormously for me to see it, because I'm not going to be expressing my own view very often in a mediation, I want to find out their views. So that tends to be the pattern I would follow before a private mediation.
Interesting. So basically, what you're saying is that you'd of course you generally have a full day mediation in when there are private mediations. You'd like to start by seeing your documents, correspondences, and or pleadings that might be available to get a better idea of how the communication has flowed. Where are we at the current situation?
Yeah.
And then have 4-5 A4 size sheets listing the key issues by the parties as to why their case is stronger before you introduce yourself to the lawyers.
I think the one point that I think your audience might need to understand is that my approach, and I think quite a lot of UK mediators take this, is not to be purely facilitative. And so I'm not afraid to engage with the parties on the strength of their case. I'm not going to express a view. I'm not going to say whether someone's going to win or lose, but I'm not simply going to ask them, what do they want? We're going to get into the detail.
No, fair. I think that is a very valid point where the clients do need assistance, not necessarily suggestions or to be told what to do, but you can be evaluating. You can assist them in the evaluation process. I completely agree. Jawad, over to you. What is your routine? What does your pre-mediation preparation routine look like?
I think Jonathan has explained what we normally do before we start the mediation in the context of a private mediation. There are just one thing that I want to add to it is it becomes very important to ascertain that who's at the table, especially in the context of commercial mediation. It becomes very important because what happens is many companies, they depute somebody who is very low in the pecking order and whose pay scale is not up to the grade where they can take decisions. Now they come and take part in the mediations, and unless you're very sure that they have the authority to settle. Now this is something that becomes very important to ascertain before you start the mediation, because otherwise it will be an exercise in futility, because simply the person will turn around and say, well, all this is very good, but let me go back to my top boss and get his consent. And he comes back and says, sorry, my boss is not agreeing. So, like for instance, yesterday I had a private mediation, the preliminary session. I always have, like what Jonathan said, we always have a preliminary session with the parties, and we call the parties and the lawyers, and we explain the process to them, what they can expect out of it, ascertain that who's there at the table. And yesterday, the one side was represented by the chief financial officer. And the very first objection that was raised by the requesting party was that this man has no authority to decide at all. So I don't want to participate in the mediation unless the managing director of the company is here. And as you know, later on it came to light that they had worked at a very personal level. They knew each other very well. So at a personal level, and he was insisting that the managing director should come. And therefore, I had to request the counsel for the responding party that please request your managing director to come for the next mediation session. So that is one thing which is very important. The second thing that we normally do is we get an agreement signed by the parties. Because right now we call it as conciliation because the Mediation Act is still not notified. We still bring it under the Arbitration and Conciliation Act in order to give some efficacy to the final settlement agreement that is reached. So we have an agreement to conciliate that is signed by both the parties, and that contains certain details about what is going to be shared by the parties, what is the role of the mediator, the confidentiality part of it. Parties have to agree to that, and who's going to be representing the parties. All these aspects are mentioned in the agreement. Yes. And the parties sign the agreement so that we have a clarity, and especially the mediator's fee, because that's a very important part. Somehow in India, we seem to be still laboring under the misconception it's a pro bono service. I mean, we all serve, right? Judges serve, doctors serve, but they all get paid. So why not the poor mediators? So the fee part of it is also mentioned in the agreement to conciliate the manner of payment. And normally both parties have to pay equally. the venue, all this is agreed upon. So it's better to have it in the form of an agreement, simply because, in the Indian context particularly, that kind of clarity is required, so that later on you don't have a problem with the parties. So none of the factual aspects, or what is the essence of the dispute. Maybe you may just, in the recital, you may just simply mention that this is a dispute pertaining to so and so contract. That's it. But then you have all these terms about the confidentiality, the fees, the venue, who's going to bear the costs, and how the mediations are going to be held, about the private sessions, the confidentiality of the private sessions, and what are the etiquette, what are the rules of etiquette that need to be followed if it is an online meeting, like if you're meeting on Zoom, what should be the etiquette that should be followed, and the ground rules. So all these things are put there, but still we do make an opening statement to the parties, because sometimes the written word can be understood in different ways by different people. So we always make it a point to make an opening statement explaining our role, particularly as mediators or conciliators. What is our role? And especially, in the Indian context, it becomes very important to emphasize to the parties that you have no power to take decisions. Okay, you may be, and I'm in full agreement with Jonathan, because sometimes in mediations you have to be a little evaluative. You have to be, you have to discuss a little more with the parties, and maybe explore different options with the parties. So you explain your role very clearly, because otherwise, especially in the court annexed mediation context, sometimes people come and call me as my lord or your honor or something. So mediators, the lawyers tend to address them as judges. So we have to clarify to them what our role is. And one of the most important things that I would like to point out here is the informality of the mediation process. Though
Right.
we follow, we sign an agreement, all those things, but yet we make sure that, especially I make it a point to tell the parties that please call me as by my first name, call me Jawad, and please tell me how you would like to be addressed. Because the tone of informality needs to be set from the very beginning, to emphasize to the parties that they are not in a formal adjudicatory setting. They are in a setting where they are going to be negotiating with each other. They are going to be having these conversations with each other. So it's very important to explain to them that part of it. So to set the informal tone, I think one of the best ways to do it is to call each other by the first name, right?
Mhm.
So it sets a tone of informality. So these are just some of the things that I just wanted to add to what Jonathan said.
I think, and it brings, I think you start touching upon the flow or the design of the process. And, that brings me to my next question, that why is process design, what is process design? What do we mean by saying, hey, you know what, let's design the mediation process, right? Or the fact that there can be a different design, there can be a different process designed for each matter. And if you can give us a case study where the process design was critical, that you felt was critical to the effectiveness of the mediation. Jonathan?
Thank you. I just wanted to say that I entirely agree with everything Jawad added to what I said. Those all form part of my normal mediation process. Um, uh, so my typical mediation day, having had the preliminary conversation, would start with me meeting each of the parties privately. We'd almost certainly, if we're in person, we're going to be in a solicitor's office, or maybe in a dispute center, not a court. That private mediations vary. I can't think of one I've done that hasn't been court annexed that I've done in a court. Sometimes it's in a hotel. So they're in separate rooms, and I see them separately to start with. Then I like to have a joint session after that. Now, that joint session sometimes is no more than good morning, thanks for coming, let's get on with this. Sometimes it's much more, because I always say it's an opportunity, not an obligation, for the parties to speak. And this is, to my mind, this is an absolutely key part of the mediation process. One of the strengths of mediation is communication. It's very often you find that parties who have been in a contract or been in a business relationship, or maybe they've been shareholders in a company or in some sort of arrangement, they've stopped talking to each other. And I think part of the role of the mediator is to get the conversation going again. Now, one needs to be sympathetic and not be too crass in just putting people in the same room where they might end up fighting each other, literally sometimes, or just shouting at each other, or there may be a power imbalance, and one needs to be aware of all these things. So, but I do like the open session. But my mediations, they don't necessarily go on for very long. Sometimes there'll be no more than, as I say, a good morning. Sometimes they're 20 minutes. They might go on for an hour. It'd be unusual to go on for longer than that. Then we split into private sessions and we go back and forth. And then if I think at some point I need to put people together again, I can do that. The process is flexible, and I just try and work out what's working and what's not working during the day, and who should be speaking to whom. And that's in a one-day mediation, but I find quite a lot of mediations now don't settle on the day. And this, I think, is quite important, to keep the mediation open, to work out what it is that's prevented settlement. It may be that one of the parties needs to go off and do some, get some more information. It may be that they need a report on something, or it may be, sometimes I've had it where there's had to be a court hearing that's addressed a part of the dispute, and then you can come back and continue to mediate the rest of the dispute. I can remember one case. It was quite a sad case some years ago, involving a whole lot of farmers who were suing the government over the way they tried to curtail an outbreak of foot and mouth disease amongst the cattle, and they'd engaged in wholesale slaughter and then burning of the affected animals. And the allegation was that this had been done negligently and had caused a great deal of damage among the farms affected because of the way this had been carried out. And so on that occasion, I actually went to the farms, and I saw the farmers on their home territory, and that was really important, that they could tell me the story where they were comfortable and where they could actually show me what the impact it had. And then I had a meeting with the ministry, and so by the time we got to the mediation itself, we were already halfway into the mediation day. We were sort of already had made a lot of progress. So I think the great thing about mediation is that you can design the process to fit the problem, and I think one of the challenges, certainly for me as a lawyer, is to assume that people want a legal outcome, and they don't necessarily. They may want something else, and to be able to try and work out what it is they're after. It might just be an apology. It might just be a recognition of the damage that's something that's been done. And so I think in terms of process, it's always important to be asking questions. You know, will this work? This is how I normally do it. Will this work for you? And normally people are quite happy because you're the mediator. They say yes, that's fine. But it's interesting to ask the question.
Yes, I think questions are a very, very important part of the process, for sure. Jawad, people say that mediation is a flexible process. It's a flexible process, but letting it be too flexible also can derail the entire process. So I'd like to know from you, why do you think, first, what is process design and why is it crucial?
Jawad, before you respond to that, sorry, I just want to come in and twist that a bit for you as well. Lawyers don't really like flexibility that much. True or false? Everyone who's joining us live, tell me whether I'm right or wrong. Lawyers don't like flexibility. They like things structured. They even get very mad about formatting. and font sizes. So when we sometimes use the word informal and flexible, in your experience, especially doing private mediations in India, do you see them getting a bit afraid of that? Or is that what do we do in this kind of situation where we got to somehow not be ourselves? We are used to one way of functioning, and that is a very structured way. So when you talk about process design, especially in the context of working with uh, parties in India. And remember that I think for most of us joining us live will agree that most mediations happening in India where parties are accompanied by their lawyers. The percentage of mediations happening with just the parties in the room is probably 1%. I can argue that, right? So there is that lawyer in a room who likes structure. So how do you deal with something like that, Jawad? And yeah, your thoughts.
Yeah, good question. We always have this tendency to either, caricature lawyers in a particular mold, or we think that, they are there to sort of, maybe hijack the process or disrupt the process in some way. But that usually doesn't happen, Jonathan, because maybe I have been lucky that I have got, in all my mediations, I have done more than maybe 800, 900, or even 1,000 mediations since I started off. Uh, it's in very rare cases that I've had a difficult lawyer, a lawyer who has not really cooperated. Okay, it's very rare. Perhaps you can count on the fingers of both the hands the number of cases I've come across. Now, coming to Nishant's first question about the process, I fully agree with Jonathan when he said that it's a flexible process. I mean, there is no one size fits all. And that's a call that, many times the mediator has to take when you first have that preliminary meeting with the parties, where you're also trying to assess how comfortable are the parties with each other. How comfortable are they, sitting with each other, breathing the same air, sharing the same space? Are they okay? I mean, is there going to be any problem? Because, my friend from UK was telling me that, once what happened, he gave the same time for both parties to arrive at the mediation room, mediation venue. And they got into the lift together. And by the time they were coming out of the lift, it was all FU and, get lost and, SU and all kinds of expletives were being thrown at each other. And he had a tough time getting them back. So you have to take a call as a mediator when when you see the parties, when you're meeting them. In the preliminary meeting, you need to decide whether this is a case where you should be having a joint session or you should be having private sessions with both parties. Now, mediation is basically a facilitated negotiation, and the whole idea is to see parties are in dispute because they have different perspectives. They look at the issue from different angles. Okay, there's no black and white here, like in law that we see in an adversarial process. There's a right, there's a wrong, but in mediation, it is a matter of perspective. So what is important is, as Jonathan rightly said, the first casualty of a dispute or a conflict is communication, because communication lapses, snaps between the parties. And if at all communication takes place, it is highly toxic. And, the kind of words you use, starting from perhaps a strong email to a stinking email. So it ranges, in that spectrum, and you really don't know what has transpired between the parties. So, but I do see a lot of value in an initial joint session, simply because the advantages of having a joint session in the beginning with the parties is, number one, when you're making your opening statement, you're clarifying what the process is, you're laying down the ground rules, and you're getting the parties to agree that they will not interrupt each other and they will not use strong or abusive language against each other. So once you do that, and then you start asking them, what can you just tell me how you're looking at this whole issue? And as the parties are speaking, the mediator is not just silently listening. The mediator is intervening, reframing and summarizing, paraphrasing what the parties are saying. So when you use these techniques, and what you're basically doing is you're enabling the other party to listen from the horse's mouth what exactly this party is trying to say. And all the time you're doing the reframing, the summarizing, the paraphrasing. So you're putting it in in a perspective that gives much more clarity to the other party, because the toxic communication that would have taken place between them would have been such that the whole issue gets distorted many times, and they have a lot of angst against each other. They're angry with each other. So when you do this, what happens is there is a certain amount of clarity that comes in the minds of the parties. So, and one more advantage of that is if you start off with a private session, now there may be a lot of information that one party is giving you, which because of the confidentiality you cannot disclose to the other party, but you may like to know from the other party what exactly that party's perspective of that is. Now, I don't know how that can be done if you start off with a private session, but in a joint session, what happens, the advantage is that because of your proactive role there, you're enabling the parties to listen to each other's perspective. Okay. Now, as again, I would like to reiterate what Jonathan also said, that there is no such thing as one size fits all. Sometimes you may have to start off with private sessions because the parties simply are not comfortable to sit with each other. There might be an imbalance of power there. There might be so many aspects of the conflict that would prevent them from sitting with each other. But starting off with the joint session has its advantages, provided the parties you're confident that the parties will not be grabbing each other's throats, okay, or they will not be punching each other in the face. As long as you're sure about that, I would prefer a joint session to start off, because that helps to, a lot of information that is exchanged. There's a lot of clarity that comes up in the minds of the parties because they're able to listen to it from a neutral perspective. Now, the fundamental thing about a mediation process is, no matter how you design it, what the design of the process is, one thing that we always emphasize on when we are training mediators is that don't jump to the solution part before you have understood the whole story. So understanding the story is very important, and that what you call as the exploration stage or the gathering information stage or understanding the story stage is a very crucial stage of the mediation, where you have to listen, understand, ask just open-ended questions. Don't bring your perspective into the whole thing. Try to listen to what the understanding the perspective of the parties is the most important, critical part of the mediation process. So if you jump that and you go into the problem solving and you start exploring options, you're not going to get anywhere. Okay, in my training programs, I always show this. There's a YouTube video which is, you can even just search for it. Funny chocolate ad, in which there is this guy who comes from a jog and he's trying to do some stretching on his car, and there is a chap who's coming in a truck having a chocolate, and he comes there, goes there up to the man, and then pushes the car over the edge of the cliff. So, mediators can end up doing that if they don't understand what exactly is the problem there. So understanding the problem becomes more important, because the diagnosis is more important before you proceed with the treatment. So when you're talking about solutions, without knowing how are the parties looking at this whole problem? Just to give you one small example of, what happened in one case. It was a matrimonial case. It involved husband and wife. And, we reached an agreement on almost everything. They agreed for a divorce. They agreed for, on the custody of the children. The alimony part of it was agreed. The agreement was going to be drafted, at which stage the wife said, I need to talk to my husband and I need to get some clarity from him about certain things that happened between us. And without that, there is no closure for me. And in my mind, I'm thinking, what the hell now? Why does she want to do this now? But then you can't, that's her process, it's her right. So I called the husband, I said, your wife wants to talk to you. And I asked her, would you like me to be here? She said, yes, very much so. And I was there. And every time she would speak of some incident that happened between them. And I would see the husband's face becoming a little, clouding with anger, because the way she was expressing it was quite, it was a little bit aggressive. So I would just quickly step in, reframe that and tell, is this what you're trying to tell your husband? And she would say, yes, that's what I want to tell. And this was going on. And suddenly the man stands up and says, what the hell are we fighting for? Baby, give me a hug. And they hugged each other. And, the whole thing got back, like they got back together. After agreeing for a divorce, after agreeing for everything, they got back together. So, the power of that reframings, the techniques that we use, and we emphasize a lot in the training programs, and which is something that, every mediator needs to really master. So how do you reframe that, and how do you paraphrase it? How do you present the perspective of the party and try to understand what their real interests are? Now that becomes a very critical part of the mediation process. So no matter how you design the process, what is very important is first your opening statement where you explain the process to the parties. Now, what is the significance of or the importance of the opening statement? I always look at it from the perspective of David Rock's scarf, because parties are in conflict because one or more of their status, certainty, autonomy, relatedness, fairness, one of these domains is affected, or all these domains are affected. So when they're coming for the mediation, they're agitated, they're upset, and when you make an opening statement, when you tell them that it is a voluntary process, you're respecting their autonomy, you're recognizing the right to walk away from it. When you're telling them that this process is not going to hurt them, it's a without prejudice process, and it's completely confidential, you're assuring them of the certainty that they have control. Okay.
Jawad, if I can just come in here, I want to
Yeah.
kind of, we're running out of time as well. I see the value in that opening statement thing. And I think both you and Jonathan have been very clear about the importance of designing it and spending enough time in explaining to them that value. And you give a fantastic example there about, how the parties actually used you to kind of, as a mediator, to kind of have that conversation, which they didn't realize they could have on their own, actually, right? And it was probably because of your presence there as a mediator that they were able to have that conversation, right? It's not like you made them have that conversation, but it was the fact that there was someone neutral sitting there who was not judging them. They could have that conversation. But not all mediations are like that, right? And there are difficult parties, there are difficult lawyers. You'll have parties and lawyers come up to you as a mediator and say, I've had parties and lawyers who come up to me and said, see, listen, I have prepped well. I believe in the collaborative spirit. I am completely in here to resolve, but they are complete scoundrels. Like, those guys cannot be trusted, right? So, and I want to put this out to both Jonathan and Jawad. What is the ammunition that a private mediator has that court and ex mediators don't have the luxury of? Kind of break that kind of an impasse. See, these kind of situations normally just frustrate court and ex mediators when parties act difficult, either during the start of the mediation or towards once the mediation already begun, there's already hours spent into the mediation. So, what's the ammunition that private mediators have to break an impasse where parties are just being stubborn? Jonathan, I'll pass it over to you.
It's a very good question, and there's never one answer. Again, it depends on the nature of the dispute and the nature of the people that you're dealing with. In the disputes I deal with, it's unusual for one party to actually be making allegations of bad faith or the fact that they're scoundrels against the other party. Maybe it's the English reserve. They might be thinking that and simply not saying it. That's we can be very good at passive aggressiveness. And so they tend to be more focused on the dispute. And I think this is where the skill of the mediator comes in. I can think of a mediation I did a year or so ago, where this man was just holding on to the fact that he thought he was right, that the court ought to give him a remedy. And I had to take him, his son was there with him. And I basically had to talk to him about life and about the future. This was a wealthy man. He didn't need the money. He just felt hard done by. And there was a proposal on the table. It wasn't what he wanted, but it wasn't that there was nothing. And so when you talk about ways to break impasse, I think you have to understand who you're dealing with. And this is the real challenge. And this is where I think a skilled mediator brings a value that people don't always realize, where you're reading the room, you're reading the individual, you're working out, because of the conversations you've had during the day, what's their motivation, what's driving this. You don't always get there. I mean, they're the obvious tools that we know about, the Whatner and the Batner, the worst alternative to a negotiated outcome, the best alternative to a negotiated outcome. I also use a metaphor of the sports ground. Forgive me, it's a very male sort of orientated metaphor. And I say the answer to this is not a point, it's on the pitch, but no one's on the pitch yet. And then I can spread that. I say, look, these guys are still on their way to the ground at the moment. Well, they're in the ground, but they're only in the car park. Let's see. And then you get to a point when you say, right, I think you're both on the pitch now. You're not agreed, but this is where, and what's other people call the zone of reasonable settlement or reasonable agreement, or it's all of that. Now, I do use mediator proposals, and I'm conscious because when I was last in Delhi talking to mediators, and I used this phrase, that got an animated response. And I think a lot of it was down to language rather than anything else. My mediator proposal is not something that anyone has to agree to. That's the first point. All I'm doing is giving a suggestion as to where both sides might be willing to end up. And this is something that comes right at the end of the process. It'll follow proposals from each side so that everyone will know what the gap is and what's there. And that just helps. Sometimes people can't bring themselves to make that last move. But if the mediator says, well, if the other side would do it, how would you respond, or something like that? That's a different question. And psychologically, it is surprising how that does enable people to move on. But you can only do that, I think, if you are comfortable that you've understood what's driving the process and what the parties are really after. So those are some of the thoughts that I've got on impasse.
Yeah, absolutely. And I think this is something that it did receive quite an animated response. I was in the room with you, Jonathan, when that happened. And I guess that's because most of us trained in India as mediators are encouraged to use the facilitative process, are encouraged to be more facilitative in the outlook. And I guess in a private mediation space, you can use that, because here's the reality for those of you who've been watching us live for the last 50 minutes. You pay for private mediation. All right. Mediators are paid for their services. Jawad said that was a fantastic quote by the way, Jawad. I'm going to use you on that about service. And a lot of people doing service, and why shouldn't they be paid for their service? So this is a paid process, and therefore the parties and the lawyers are expecting you to help them get to a resolution. They're not expecting you to threaten them. They're not expecting you to force them. They're not expecting you to coerce them. They're not expecting you to basically push and cajole them to make I would say, get them into a space where they're uncomfortable to find a solution, but they're expecting you to help them. So if whatever it takes, right, and if that last step, plan ZZZ plus, is a mediator's proposal, then so be it. And we don't have enough time to dive deep into the mediator's proposal today. I promise our great friend Claude Omar that we're going to get into that with him. But for this last point of just stitching together, building trust in private mediation, and especially in the Indian context and the Indian market, Jawad, what else can we do? I mean, once again, coming down to this $1 million question about billing, right? We have been all in this place where someone's called us up, asked us what mediation is all about, or what are the services we're providing. We get all the information, and we never hear from them again. And sometimes we don't know why. Sometimes we know why. It could be financials. It could be just they don't believe that you are going to be able to bring the other side to the table. It could be all kinds of reasons. But from the billing perspective, especially for folks who have already gone deep down into litigation, they've spent months and maybe years into litigation, spent millions of dollars or rupees into into litigation. How do you now ask them to invest in a new process? How do we actually market mediation? So quick fire answers on this. We just got 5 minutes to go.
Yeah, see, the answer is very simple, Jonathan. I think the best way to do it is, I think, to institutionalize mediation. Have mediation institutions so that people have more confidence that, the mediator that you're engaging is qualified for the job, and the institution is going to take care of the whole process. And there is always, better accountability and better quality when you approach an institution for mediation. Not to say that private mediators should not work on their own. I'm not saying that. But having an institution to engaging an institution in this process is always very helpful, because this is where I think what happens is one of the questions that's frequently asked is, there's a possibility that mediation may fail, so why should I go for mediation and waste the money in trying to get the matter mediated when I can straight away save the time and go for a litigation arbitration? And my answer to that is, litigation and arbitration always fail, because you may get an award, you may get a degree, but you don't see the color of money. So in a mediation, it's in your hands, and it's up to you to find a solution that works for you and works for the other side. So one thing is the institutionalization of mediation. The other thing is, I think we need a little more, awareness on the side of the lawyers also, because lawyers play a very critical role in advising their clients on how to, go about finding a resolution to the problem. So I always tell lawyers that you have to be problem solvers and not problem inflamers. So that is something that is very critical for a lawyer to do. As a lawyer, what is your role in advising a client? So when I became a lawyer, my father gave me a plaque to be put in my office. It was a quote of Khalil Gibran, which said, "The greatest trust between man and man is the trust of giving counsel." So you're giving counsel to somebody is trusting you and coming to you, and your job is to show them the best way out of the problem, right? So that is something that has to be done. And the question, once I was asked this question, that, why should I go for mediation? To repeat the question again, why should I go for mediation when I don't know what's going to happen in it? So my answer to that was that, if you know that you have a disease, you have a problem, and medication is an option for you and surgery is another option for you, which would you prefer? Would you go for medication or would you go for a surgery? So the choice is something that you have to make. The medication may help you to overcome the problem. So, and in a much quicker way, in a better way. Okay, the surgery might leave some very lasting impact on you. So you have to make a choice on that, okay, ultimately. And for this, I think the most important thing is the awareness. And I think the institutionalization would create better awareness. And there have been challenges because the courts have been, largely responsible for, popularizing mediation in India. Because but for the court annexed mediation program in India, this would not have taken hold at all. Mediation would not have taken roots at all in India. So, but now I think it is time to, privatize it, make it a profession. So unless you make it a profession, a paying profession, that is where the quality will come. Okay, because when the quality comes, when there is a competition, there is more better quality. Okay, when you have a number of options before you, you have to offer the best to the people. Okay, if people go to a good lawyer, they go because the lawyer is good, right?
And I think what one would add to that is the fact that as the lawyers get comfortable with the process, so they're going to see the value. And I think that's, and when you can start to have statistics and that 3/4 of cases that go to mediation settle, it becomes a virtuous circle, and the lawyers then want to go to mediation, and because I mean, for the lawyers, that's a fantastic opportunity for them to showcase their skills and to get to know their clients better.
Yeah, I think there is still a lot of apprehension in terms of, once again, billing from the lawyer's perspective. And we've addressed that in a couple of the last episodes on the Mission Mediation podcast, where we spoke about the role of a lawyer, and we didn't shy away from talking about billing, especially for a lawyer.
Well, I was told on that you can put a big bill into a client just once, and because you'll probably lose the client. But the mediation, if the client thinks this is a great process and hasn't cost me, your status as their lawyer goes up, and you see people recommending these lawyers because of the results.
Yeah, just to add to what Jonathan said, in the Indian context, Niti Aayog statistics say that 97% of disputes don't come to the courts. So what, the few lakh lawyers in India, a few million lawyers in India are making out their money out of is 3%. So why does the 97% doesn't come? It's because people don't want to waste their time. They live with the problem, or they find some extrajudicial methods of resolving the problem. So if you offer them a method by which they can, it's in their control and they have the ability to get a resolution. They're looking for solutions. They don't want judicial precedents. They don't want their names to figure in some law journal somewhere. They want a solution to the problem that they're facing.
Yeah.
So once lawyers realize the value of what they're doing and the value of what is going to come back to them, in terms of, as Jonathan said, you're increasing the volume of your work. You're expanding your portfolio, right? So that's something that lawyers need to understand.
Yeah, and that's interesting. I think we didn't have enough time to cover, of course, we're running out of time, but this has been such an interesting conversation, especially just to bring in the context of how we need to build trust, not just within private institutions that currently exist, but also within the lawyer community, because they are the gatekeepers to pre-litigation mediation coming through. I like what you said, Jawad, once again about a lot of people are living with that problem for the rest of their life. They don't want to come and put it forward because of the cost. Look at the stats out there. It's around 12 to 15 years for litigation civil case, the average litigation civil case. And the average mediation, private mediation, is around 3 to 6 months. So if you're joining us live and you're struggling with a dispute, whether you're a lawyer or a user, you know where to find us. You know where to find Jonathan Lloyd Jones. You know where to find Jawad. You know where to find Nishant and myself. This has been an absolute pleasure listening to you talk about how private mediation really kind of gives us an opportunity to connect with the parties as a mediator. I think that's missing. That's how I summarize today's session. Both of you spoke about this, that it gives the mediator an opportunity to be human with the parties and the lawyers, to kind of, as you said, break the ice in the start, allow them to call you by your name, spend time in preparation, ask them to bring in that evidence, which I thought was a fantastic idea by you, Jonathan. I think lawyers love it. When you say, hey, bring in your evidence into that pre-mediation round, they'll be like, yes, I can now showcase my skills. So I think let's get the stakeholders involved. Let's make them feel like they have a place at the table and make it an inclusive process. That's how I would like to summarize today's session. Thank you so much for joining us live. The next episode is also going to be on private mediation in a couple of weeks. See you on that one. Jawad, Jonathan, Nishant, thank you so much once again.
Thank you.
Thanks.
Thank you both the Jonathans. And it was a privilege to share the stage with Jonathan Lloyd Jones, because he's my guru also, because I have undergone training with him. So it's a real privilege. Thank you so much.
That's very sweet.
Enjoyed it a lot. Thank you for inviting me.